CBI special PP, CBI ના special PP.
CBI special PP.
CRM 84/2026 सुनील शाह वकील श्री R.A. बारोट
वकील श्री R.A. बारोट सुनील शाह
मनीषा पटेल सेशंस
BS पटेल
ABPS पटेल
सेशंस 5/18 रमन भाई मारवाड़ी वकील श्री M.R. शेख
वकील श्री M.R. शेख
सेशन 16/19 रोहित भाई राजेश भाई टीना અને આશાબેન વકીલ શ્રી M. રાજપૂત
वकील श्री M. राजपूत
આયુ એડી ચાવડા સર એમને અવેલેબલ વોરંટ કરેલું હજુ આવ્યું નથી સેશન્સ 261/19 સુધીર કુમાર વકીલ શ્રી A.K. શેખ
वकील श्री A.K. शेख
સર એમાં એક સહાયદ હાજર છે
लिखित वाले थे
હા 261 સહાયદ હાજર છે વકીલ શ્રી A.K. શેખ
वकील श्री A.K. शेख
बीजू
पुलिस कांस्टेबल ब्यूटी बॉय
सेशन 8/20 अशोक भाई गौरिया
अच्छा बाकी रख दो
हाँ
ना
वकील श्री D.S. मौर्य
वकील श्री D.S. मौर्य
फर्स्ट डेट से जनवरी 23 का थी 23 रख दीजिए
सेशन 3/21 शकुंतलाबेन वकील श्री M. राजपूत
वकील श्री M. राजपूत
कॉपी मंगा लीजिए फाइल मंगा लीजिए
सेशन 89/21 जगदीश भाई राजपूत यूपी पीछे नंबर 20 बाहर है समरजीत धनीराम देवी देवी मीना देवी आनंद
समरजीत बॉय
धनीराम
देवी देवी चलो
आनंद राजपूत
वकील श्री S. पासी
वकील श्री S. पासी
अका बेन
તમાર બેબી દેવી ને નામ મીના દેવી 5 મિનિટ સર બધાએ હાજરી કરાવી છે
આવેલા છે
હા સર ખાલી આનંદ બાકી છે 6 નંબર
आवेला
वकील श्री S. पासी
वकील श्री S. पासी
वकील श्री P.B. पहाड़िया
वकील श्री P.B. पहाड़िया
वकील श्री S.N. मिश्रा
वकील श्री S.N. मिश्रा
P.P. ની સામે सेशन 69/22 वकील श्री M.D. भट्टी
वकील श्री M.D. भट्टी
આ બધા આરોપી બાકી છે આ એનો ક્રોસ કેસ છે સર 290/22 એનો પછી 10 નંબર
ओके मोहन भाई परवार
290/22 महिपाल सिंह वाघेला वकील श्री M.R. जाडेजा
वकील श्री M.R. जाडेजा
PPBC चावड़ा APPBC चावड़ा સર 69/22 માં ફરિયાદીનું સમન્સ બદલેલું છે ડોક્ટરને બદલેલું છે રાજેન્દ્રસિંહ વાઘેલા લગા આવે તો કદાચ આવી
આજે છે 290 માં કોઈ નથી
સર 290 માં ડી બાકી છે આપણે યાદ
क्या
સર નથી હવે આ બધા
मोहन भाई परवार एक केस में तो पीला के
महिपाल सिंह કેસમાં છે 290 મળે. બોલો નામ
એનું
બોલો.
નામ બોલો.
મહિપાલસિંહ, ભુજેન્દ્રસિંહ, નરેન્દ્રસિંહ, ચિરાગસિંહ, હસમુખસિંહ,
290 માં છે.
હા સર, કેવલસિંહ, રાજેન્દ્રસિંહ વાઘેલા, સંજયસિંહ, ભરતસિંહ, યુવરાજસિંહ, જયેન્દ્રસિંહ વાઘેલા, યશપાલસિંહ, અર્જુનસિંહ,
3 જણા છે, નથી 3 થી 4 નથી.
4 નથી, 5 નંબર નથી, 9, 10 અને 11, 5, 9, 10, 11, 12. વકીલ શ્રી M.R. જાડેજા,
વકીલ સાહેબ જડેજા,
વકીલ શ્રી M.B. ભટ્ટી,
વકીલ સાહેબ ભટ્ટી,
સેશન્સ 329/22, રાહુલ પટની,
રાહુલ ભટ્ટી,
વકીલ શ્રી V.N. ઇન્દ્રેકર,
વકીલ શ્રી વીરેન્દ્ર,
ગૌતમ પટની, ગૌતમ
ગૌતમ ભટ્ટી,
સર એનો પુરવણી છે 1300
રાહુલ
પેપર
પટેલ કોઈ
નથી સર, સિરિયલ નંબર 16 ઉપર છે એનું જ છે પુરવણી
ગૌતમ બી નથી.
નથી સર. મહેશ પટની,
મહેશ ભટ્ટી,
સર એનો સમસ્યા બજાર
16 છે.
હા 16
એ બી નથી.
ના સર.
Okay. સમજ થઈ ગઈ, સાવ થઈ ગઈ.
સર 329 માં સાહેબના સમય બજાર એ નથી આવ્યો. સુરજ દિવાકર,
સુરેશ દિવાકર,
ના, 998.
સેશન્સ 998/23, સન્ની ગોહિલ,
સાહેબ છે.
સર સમય સાથે આવ્યો ડોક્ટર માટે બતાવ્યું તો ડોક્ટરને સમજ કરેલું છે હું આવી નથી બીજું પણ લઈ આવો.
બીજુભાઈ,
ડોક્ટરને સમજ કરે લખો. વકીલ શ્રી વીડી મસિયાવા,
વકીલ શ્રી બસ્યાવા,
1027/23, મોહમ્મદ ફૈઝલ,
મોહમ્મદ ફૈઝલ,
સર 1027 મળી આવતું નથી અવેલેબલ વોરંટ વગર
બીજું મળી આવે.
ના સર. સેશન્સ 281/24, ગોવિંદભાઈ યોગેશભાઈ, વકીલ શ્રી P.H. વાઘેલા, હા કરે.
281
ભૂકા કરજો ને. પંચો અજયભાઈ વણઝારા,
અજયભાઈ વંજારા,
દીપક વણઝારા,
દીપક વંજારા,
બે પંચોને બજાર રાજુ નહીં ખબર હવે ખબર પંચો કોઈ આયા છે તપાસ કરો.
અજયભાઈ દીપક
અજયભાઈ આ છે અને દીપકભાઈ
પંચો છે.
એ તો આરોપી છે. એક હાજર છે
કયું પંચ છે?
સર એ જોઈ લો. NIA 1/22, 4/22, 1/23, 2/23, 7/24.
પેસ્ટલ કાપડિયા,
સર એમાં સર 1/22 NIA એમાં આરોપી નંબર 1 અને આરોપી નંબર 3 થી 10 VC માં હાજર છે. નંબર 2 બેલ આઉટ છે જાતે હાજર છે. ગોવિંદ રાજુ, સિરિયલ નંબર 4/22, સરબજીત સિંહ, સર એમાં એક નંબર આરોપી સર 2 થી 8 હાજર છે. 9 નંબર જૂની જેલમાં છે બાકી છે. હા બધા જ હા યુટીપી છે. 9 નંબર બાકી છે સર એમાં જૂની જેલથી કનેક્ટ થશે. 1/23 છે સર એમાં હરપ્રીત સિંહ છે. સર આરોપી નંબર 1, 2, 3 હાજર છે. 4 ને 5 ની બાકી 5 ની 5ની એક્ઝમ્પશન છે, બેલ આઉટ છે, 4 ને 5. 6 ને 7,
5
4
exemption
5ની એક્ઝમ્પશન, 4 ની બહાર. સર 6 ને 7 હાજર છે, રિસીવિંગ.
આઠથી જે છે
કંપની
8 થી 14 એ કમ્પ્લીટ છે
હા સર.
એ તો કોઈ છે નહીં ને મતલબ
સર એમાં જે છે એના
8 નંબરની કંપનીના ઓનર
એ અહીંયા
ગોવિંદા રાજવા,
આપણે હાજર કરતા.
9 નંબરની કંપની એના ઓનર
કોઈ બીજા બધા છે
હા. પાછળ 2/23 છે, એના પંકજભાઈ છે, વીસીપી હાજર છે. સર 4/24 માં 1 થી 9 જે આરોપી છે એ આગળ કોમન આરોપી છે, આગળ જે થયા એ છે.
4 થી 13 છે
એક
એ
થી-
બેલ આઉટ છે
હા 10 થી 13 છે સર એની એક્ઝમ્પશન. 7/24 માં કોમન છે, નીચેનો એના ઉપરના જે હતા એ.
exemption ને બધા ક્યાંથી છે exemption કેમ આવે છે regular
કેશભાઈ વ્યાસ, એચ. એ. પટેલ, PM ને.
exemption regular
આવતી મુદત સર
રાખજો બધાને
આવતી મુદત બધા હાજર રાખ્યું.
પછી આ 7/24 માં એ 4 વાળા જ છે exemption વાળા
હા સર.
ઓકે એમાં કોણ હતું કેમ
સાહેબની ગુરુબાની ચાલતી હતી કે
હા એમ કે નથી
સ્પેશિયલ બીપી એમજી કાપડિયા,
આજે
સ્પેશિયલ બીપી એમજી કાપડિયા.
ના
બેટર વિવેક પડ્યા.
ના પડી હતી તમને
હા સર.
નથી
સર
ઓકે
Yes, no, it's M of star, ID Pathan, J.S. Over, MC Agil, Anna Loda. Okay, RM Ansari,
બકરી સિયારા મંસાઈ.
20 કે 21 લખ્યું 20 20 21
January, January, 20. Bail out જમા કરી. Govinda Raju, 20 January, 28 January, 20. आज विटनेस नहीं आया. यूडी शेखावत सर ने मुदत अर्जी दी. सर एक सेशन केस में तारीख है 105
કઈ છે
105 हजार मत तारीख
અહીંયા નહીં હોય તો આર્ગ્યુમેન્ટ પડી છે
બીજી જગ્યાએ
अंदर सर Yes. તમારા 3/21 માં આરોપી
એફઆઈઆર આવી છે એ હાજર છે.
ક્યાં છે નામ પૂછું
હા
જેલ સાબરમતી જૂની જેલ શું છે?
સેન્ટ્રલ જેલ જૂની જેલ
જી સર.
હાજી.
પૂછી તો હાજર પૂરો
અહેમદ મોઇનુદ્દીન,
અહેમદ મોઇનુદ્દીન.
આઝાદ સુલેમાન, આઝાદ સુલેમાન,
આઝાદ સુલેમાન તમે જતા રહો સાહેબ. આઝાદ સુલેમાન થઈ જાઓ.
મોહમ્મદ સુહેલ,
હા એનઆઈએ એફઆઈ 1 ઓફ
126,
એનઆઈએ આરસી છે
આસિફ
1 ઓફ 26
126, NIA AMG
3 એક્યુઝ છે
3
હાજરી બોલે કે ડેટ આપી દીધો
23 તારીખ પિન્ટુભાઈ
હાજી સર. તમારે રજૂઆત કરવાની સર, આમને એક રજૂઆત કરવાની છે.
ના અત્યારે રજૂઆત નો નથી.
જી સર.
જસવીર ચેલા રજૂ રાખજો.
હાજી સર, બોલાવી લીધેલા છે.
રજૂઆત થઈ ગઈ. કેસ ચાલુ.
વકીલ શ્રી એકે શ્રી એક
હાજરી પૂર્વક કઈ સાંભળવું નથી.
તમે
જી સર.
શાહેદ આદેશ
એના કેસીસ વાળા જેટલા છે ને એટલું બધા લીવ થઈ જતો.
સેન્ટ્રલ જેલ NI 1/22, 4/22, 1/23, 2/23, 4/24 ને 7/24, 20 જાન્યુઆરી
રિપોર્ટ છે એમ કેજો.
આપણે વકીલ શ્રી યુડી શેખાવત સાહેબ અવેલેબલ નથી એટલે એમનો મુદત રિપોર્ટ છે 20 જાન્યુઆરી.
તો બધા ત્યાં રવાના કરી નાખો.
NIA જવા
વોટ ઇઝ ધ નંબર ઓફ ધેટ
11,597. 11,597 para 5.
Para 5 11
11,597, sir.
25.
11,597, which is pending, which is coming on 13 April.
Okay, 1 minute. That is pending,
Yes, sir.
and that matter is kept on
13 April, sir.
13 April 26.
26.
Yes.
So now we have moved another application before this London trial court that we
Yes.
want to travel abroad. We need to renew our passport. Passport is a fundamental right. And
You have moved application for
for renewal
One.
of passport and traveling abroad, sir.
you applied for passport,
Yes, sir.
or you were intending to apply for passport.
Not intending renewal, sir.
Application for renewal of passport was filed.
And traveling abroad.
Application for renewal
Yes, sir.
of passport
And traveling abroad, Lordship.
permit to travel abroad.
Yes, sir.
Yes,
So the honorable court has asked for an affidavit that if you.
was filed.
Yes, sir, affidavit to be
What-
filed to if the accused as
What was
faith.
what was that application exhibit? That copy of that application is appended?
Application is not submitted, sir, here.
Yes,
The
yes,
issue was a little this
yes.
thing.
Then,
The
yes.
honorable court has.
What happened there?
Honorable court has asked for an affidavit saying the
The
accused
honorable
would give an
court.
affidavit, he has faith in the court, which I declined. Now there is a deadlock kind of a situation which has emerges
Hmm.
and
Your application for renewal of passport and
has been,
permitting you to travel abroad
right, sir.
was filed and rejected.
No, kept pending. Nothing was done. The lawyer was asked to give an affidavit that accused should submit an affidavit, he has faith in the court, to which I declined.
Was filed and received application is pending.
Yes, sir.
Yes. Any order was passed there?
No, nothing, sir.
It was oral order.
No, oral he said that you go, whatever remedies you, I won't decide, I won't transfer. Even request was made to transfer to another coordinate bench, coordinate judge, but nothing was done, sir.
Application for renewal of passport and permission to
Travel abroad, sir.
was filed and said application is pending.
Yes, sir.
This application was filed on which date?
Sir, 26th it was filed,
26/12.
12th, sir. 29th it came for hearing.
Pending. 26/12.
Yes, sir.
Yes. Yes.
So humble request is now a deadlock kind of situation has emerged of having a passport is a fundamental right. If it in the given set of circumstances, if this
Yes,
can be
one month. Passport is, having a passport is a fundamental right.
is under section Article 21. Menka Gandhi versus State Union of India, The decision says so. Madam,
Yes.
Madam. Now, a new development has also come.
Yes.
There is a judgment of Bombay High Court which says this Alice offence, which I am facing trial, is
Yes.
not an offence during that period. State has gone in appeal against the judgment of Bombay High Court in SLP criminal to Supreme Court. Supreme Court has heard the matter in April 25. Judgment reserved.
One.
Yes, sir.
What was the order passed by
Sir,
Bombay?
there are two. If I draw your attention to the court
Yes.
number 17 is the one order. Court number 17 ऊपर लिखा है sir.
Yes, code number 17.
Sir, this is an challenge to a judgment passed by Bombay High Court. Bombay High Court says this particular offence for which I am facing trial is not an offence during that period because statute was amended only 2018. Only after 18, alleged offence of giving bribe, voluntary
Where
giving.
is that order of Bombay High Court?
Sir, I am giving. Madam.
Yes.
So the flag page, page number 25, I flagged it. The act of mere offer voluntary made by petitioner without any demand from the complainant cannot be made punishable under section 12 of the PCA since the said act was not attracting any provision prior to 26/7/2008, even though amount has been found on the table of complaint in the thread. Now this is a judgment passed by division bench of Bombay High Court.
Yes.
Now, against this judgment, the state has gone in appeal in the Supreme Court. Supreme Court has heard the matter on 22/4/25 and judgment has been reserved.
Yes.
Now, another matter from Odisha, similar period,
Yes.
they went citing the same judgment of the Bombay High Court. Now, the para 2 of this judgment says, we are informed that the said decision of Bombay High Court having been carried in appeal before this court, the parties were heard and the judgment has been reserved by coordinate bench of 22nd April 2025. In such view of the matter, we do not propose to proceed further with this special leave petition. It would be appropriate to await the judgment to be rendered by this court on the aforesaid appeal.
Yes.
So my humble submission, this court being a subordinate court is likely to take a while till the decision comes from the Honorable Apex Court in the matter.
Yes.
So my humble submission is looking at the facts and circumstances of the case and my right, because tomorrow if the judgment comes in my favor, then all this period of
What this matter has to do with Europe's matter?
no, sir, this is a direct saying, yes, section 12, I am facing a trial under section 12.
That
This
whether
is
you are party to this proceedings, you are party to this.
doesn't matter, sir,
You
because
are party to this proceedings.
no, I am not. I may not be party to this, but
what
this
judgment,
is a law.
But what this judgment has bearing on your case?
That is what I am trying to explain, sir. I am facing a trial of section 12 for a period from 1980 for period 2004. Now, this judgment says prior to 2018, 26, this section 12 doesn't apply for this kind of allegation.
Whether you moved any application before this court?
We have moved an application. Yes, I have moved today, sir. I have given this application today.
With regard this too?
Including these two, sir.
Then that court will decide. I am not that court.
नहीं सर, मैं सिर्फ आपके ध्यान में ये फैक्ट्स ला रहा हूँ to decide my application. I am not asking you to decide this. I am bringing my.
These are your contention.
These are my contentions.
Yes, then
my prayer is this whole scenario is likely to take a while for deciding the case. In humble submission, my right to travel abroad and my passport renewal. So if this particular application of passport could be transferred to another bench, I will be blessed.
yes. Anything else you want to?
No, sir. This is the
You want to your case to be transferred or particular application to be transferred?
application, sir.
Yes.
सर एक बहुत सिंपल सी बात है, इन्होंने सर बोला हुआ है कि हमें कोर्ट में फेथ नहीं है, तो उसके लिए जज साहब मांग रहे हैं कि आप बोल दें कि कोर्ट में हमको आपको फेथ है, हम डिसाइड करते हैं, मेरिट पे डिसाइड करते हैं। बट ये बोल रहे हैं कि हमको फेथ भी नहीं है और आप डिसाइड भी कर दीजिए।
मेरे पास सेपरेटिंग तो नहीं है।
नंबर 1 सर। नंबर 2 सर, ये
और
केस
आपका व्हाट इज योर
सर माय नेम सत्यम यादव, पीसीबी
एस सत्यम यादव?
सत्यम सर, SATY
Yes.
यस
SATYM.
यस
Yes. Special PP?
CBL।
Yes. Yes.
सर इन्होंने कोर्ट में ये कह रखा है पहले से ही कि हमको माननीय कोर्ट में फेथ नहीं है, जो लर्निंग ट्रायल वहां पर कह रखा है कि हमको फेथ नहीं है। अब जब वो फेथ नहीं है, फिर ये एप्लीकेशन मूव करते हैं, तो वहां पर न्याय कैसे होगा? तो उन्होंने माननीय कोर्ट ने सिंपल कहा है कि एक आप एफिडेविट दे दीजिए कि हमको कोर्ट में फेथ है, तो हम डिसाइड कर देते हैं। इस मैटर को एस्केलेट ही नहीं करना है सर, सिंपल एफिडेविट दे दी कि हमको फेथ है, वो डिसाइड कर दें मेरे पे, उसके अगेंस्ट में आपको कुछ करना है वो आप कर लें। सिंपल सी बात। ट्रांसफर एप्लीकेशन माननीय कोर्ट में आई हुई थी, मैंने उसी दिन माननीय आपके कोर्ट में सर, माननीय कोर्ट के समक्ष मैंने आर्गूमेंट भी किया हुआ है। आपने भी सर यही बोला कि जो लर्निंग ट्रायल कोर्ट में मैटर चल रहा है आप वहां पर चलाइए, ट्रांसफर रिजेक्ट की मैटर सर डिफेंस एविडेंस स्टेज में।
Yes.
ये सब केवल डिले करना चाहते हैं कि फौरन भगना
वो
चाहते
बात
हैं।
yes affidavit to you were asked to submit an affidavit
सप्लाई सर मैंने
that he has faith in the court. ऐसी कुछ affidavit?
यस यस, क्योंकि सीधे एलिगेशन लर्निंग ट्रायल कोर्ट पे लग रहा है कि मुझे फेथ नहीं है।
मेरे पास सर इस अंबल समझने का कुछ जो इन्होंने
Yes,
आर्गुमेंट किया उसका
yes,
कारण ये है कि सर कि मेरे पास कोई
What else you want to think?
तो मेरा ये कहना है कि लर्निंग ट्रायल कोर्ट रेडी है, वो इनका मेरिट पे डिस्पोजल सुनने पे रेडी है, इनको कोई इशू नहीं है। तो इसलिए ये एक सिंपल बोलते हैं एफिडेविट देते हैं कि हमको फेथ है कोर्ट पे, लर्निंग ट्रायल कोर्ट में डिसाइड कर देगी।
Yes.
और जहां तक सर
क्या इनको कॉपी दी आपने affidavit की?
हाँ सर, थैंक यू सर।
हमारी सर रिसीव करो, रिसीव करो।
ये रिसीव कर लिया, वो एक
आपको कुछ और कहना है?
हाँ सर, हमें ये कहना है कि एक चीज और है, ये ट्रांसफर जो लेना चाहते हैं पीली के हमें फॉरेन जाना है सर, केस डिफेंस एविडेंस स्टेज पे, और काफी समय से इन्होंने डेडलॉक कर रखा है। कभी माननीय इस कोर्ट में एप्लीकेशन आती है, कभी हाई कोर्ट में जाते हैं, कभी कहीं जाते हैं, हर एक स्टेज पे मल्टीपल एप्लीकेशन, मल्टीपल माननीय पीजे साहब
बिल्कुल ऐसा है, देखिए वो उनकी रेमेडी है, इज अवेलिंग द रेमेडी।
यस, वही मैं सर कोर्ट के नॉलेज पे लाना चाहता हूँ, कोर्ट के रिकॉर्ड पे लाना चाहता हूँ कि सर
एनीथिंग एल्स वांट यू वांट टू से?
ना सर, यही मुझे कहना है, डिफेंस स्टेज पे केस है और इस स्टेज पे इनको टाइम बाउंड करके ट्रायल फेस करने के लिए माननीय कोर्ट आर्डर कर दे,
अरे
तो इनको भी न्याय हो जाएगा, हमको भी न्याय।
सर आपका तो
दिस इज एन एप्लीकेशन फॉर ट्रांसफर,
यस
seeking transfer prayer.
यस
I am not the superior court of CBI court.
सर।
चलिए, और आपको कुछ कहना है और?
नहीं सर, बस
चलो,
मेरा आपका सबमिशन ये है कि मेरे पास कोई रेमेडी नहीं है, दैट्स व्हाई आई हैव टू फाइल एप्लीकेशन फॉर दैट कोर्ट ओनली, इफ इट कैन बी
ये जो
ट्रांसफर्ड।
एप्लीकेशन उन्होंने दी है 303,
यस,
that is decided or that is pending?
नहीं पेंडिंग 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 फेथ की वजह से सब पेंडिंग, एक ही वर्ड है
13 1 order fee.
Applies. Thank you for the hearing, sir.
Yes.
Sorry if I have just said
नहीं,
some wrong words.
and now
It
you
was
02 matter. Yes, चलो। હવે આટલી મેટર આટલી બધી મોટી થઈ ગઈ છે બધી કાગળો આવીને Yes.
Because the charge on the accused is this wise. 302, 301 and 120.
JZ Sheikh. Yes.
Because this case is not merely a weak case, but not the case where the prosecution has failed to prove beyond the reasonable doubt.
એ છેલ્લે બોલજો આર્ગ્યુમેન્ટ છેલ્લે થાય.
It may not, because from the initiation of that prosecution, at the
Yes.
very end, wherein the inquiry was been issued, and from the very fag end of the trial,
Yes.
wherein the witnesses were examined and documents were verified.
Right.
There is no eyewitness of the incident.
Okay.
There is not a single recovery or discovery been made.
One. No eyewitness. No recovery.
What discovery has been made?
Public discovery.
And my lords, the
One.
FSL as well as from the
At the instance of accused.
at the instance of the medical evidences,
ગુજરાતી આર્ગ્યુ કરો.
Gujarati sahib,
ગુજરાતી નહીં ફાવે.
થોડું tough પડશે.
હા એટલે એ બેન્ડ પહેર્યું ને એટલે ખબર પડી ગઈ. હા.
Lords,
Yes.
on perusal
The
of the
first contention, there is no eyewitness to this.
There is no
Second
eyewitness.
contention, no recovery or discovery at the instance of accused.
my lords, third contention of mine is upon the medical evidence.
Medical evidence. Yes.
The whole trial proceeding, when the FSL was conducted, not in this very proceedings, there were two FSL conducted. Initially, the trial was, the investigation was perused on the basis of 306, wherein first of all, when the body of the accused, of the victim was not found,
Yes.
the prosecution was initiated in 306, and by way of 306, the investigation was conducted.
The initial complaint was under 306.
Under complaint was under not 30, but as nobody was came to be found at the initial time of investigation, the body was sent to FSL under the pretext of 306. Now, on the first pretext, when it was sent to FSL, no cause of death can be ascertained at that point.
Subsequently been નથી આવ્યું. આવ્યું છે?
Subsequently, sir,
નથી આવ્યું cause of death?
when all the accused persons were arrested, ત્યારે પણ સાહેબ કંઈ આવ્યું નથી. અને સાહેબ એને subsequent પણ આ સાહેબ આખો report, it was sent before notes the board of medical. Board of medical માં પણ the cause of that cannot be ascertained. On basis of that notes, the prosecution has prosecuted on the basis of that there was a strangulation first from the father's side. Secondly, my lords, she was hanged. Now, as there is no medical evidence as such, so these two contentions of them are neglected and cannot be proved on the very trial.
The prosecution is riding on two horses.
Two horses.
One under section 302 and another under section 302.
306 initially they were traveling, not out of nowhere. This came to be converted into a 302. So, notes the very reason why this was converted to 302 was with the arrest of Massa of the present deceased.
Yes.
According to the prosecution notes, there was a confessional recovery or the statement of that very accused was recorded. But my lords,
Massa of?
Massa of the present victim, the deceased person.
Yes.
Now,
He
when
was arrested?
he was arrested. Initially, he was arrested.
Yes. Yes.
Now, my lords, subsequently, when he was arrested,
Mm.
his confession came to be taken up. Now, sir, in his confession, extrajudicial confession, one pancha was called up.
One. Confession of accused?
Of the accused. Accused number 2, Samarjit.
A2,
A2,
Samarjit.
Samarjit.
Yes.
So the punch witness,
Hmm.
wherein he was been made this confession statement.
The confession, actually, confession.
That's section 27.
Yes.
That's the Panchayat
What?
style.
Document, exhibit.
Exhibit code.
आपको अपनी कॉल डिटेल्स सब कुछ yes,
Yes, prosecution witness 2. Exhibit 24.
exhibit 24.
Exhibit 24. Is that Pancha?
One. Yes. चिराग कुमार प्रजापति.
Yes.
Yes.
That's that exhibit on exhibit number 29, prosecution witness 5. The site of offense Panchna. He has also turned host.
Inquest पंचनामा.
Inquest Panchna.
Yes.
Then from 1 till 6, everyone has turned host.
PW 1 to 6.
1 till 6.
All are bunches.
That's all our Panchas.
Yes.
Because the chronology of the event is this wise.
Yes.
On 18/11/2020 and on that day before,
Yes.
it comes from record of various statements of the prosecution witnesses.
Yes.
Lord's Ravindra,
Yes.
who is the Lord's lover of the present deceased, and also Lord's prosecution witness 13.
Oh. PW.
In short, I'll give the exhibit number in
Yes.
midnight.
Yes. The accused are all the relatives of deceased.
Accused persons are the familiarity of the accused. Prime Lord's accused number 1 is the father. Accused number 2 would be Lord's master. He is Nana.
Yes.
Who is Lord's It's a beg pardon. Not second is Mama, not Masa. Now, all are family relatives.
Yes. Yes.
Before 18/11/2020,
Yes.
Ravindra in his own statement and also various other statements, that is Ravindra's brother, who is not prosecution witness 7, Mahendra,
PW 7.
PW7, by exhibit 39.
Yes. Who is
who is brother of this Ravindra, the lover of not present
PW7, Mahendra Kori.
Mahendra Kohli. In his statement, and not also in the prosecution witness,
Brother of Ravindra.
brother of Ravindra.
Yes.
In his statement, it comes that these both were under love relation
Yes.
before 1811.
Ravindra as well as
Ravindra as well as the
Yes.
the present deceased.
yes.
I mean, sir, from statements of this Ravindra, it comes on record that they used to travel in same bus. They used to talk regularly, and Milords Bharti has initiated Milords asking for proposal of marriage, as per his argument.
Yes.
Milords, on the contrary, there is nothing on the record which would suggest that this family member, that is the accused person, has ever Milords initiated any case against this very Ravindra.
Yes.
No kidnapping complaint was at all registered, no threat allegation, Milords. Now, Milords, comes the next point of event. It is 1911-2020.
Yes.
Now, in this very day, Milords, as per prosecution witness 7 Mahindra, that is exhibit 39,
Yes.
prosecution witness 13 Ravindra, exhibit 40 Milords, prosecution witness 15 Sachin,
Yes.
that is 76 Milords, all other prosecution witness 16 to 19,
Yes.
that is Milords Gulshan and others who are friends of this Mahendra, the brother of the lover.
Yes.
All Milords have a similar take in their statements.
One. Yes. What did you say of PW7?
PW7
Mahindra.
Mahendra Milords.
Yes.
He goes on saying that Bharti had earlier run away on this 1911-2020. So he got a call from a third party, namely Ashish, who is not alleged to be the brother of the present victim.
Yes.
Now, this is very important perspective. This Vice
Yes.
this Ashish, which will be coming in the story further and that this Ashish has bet the lover of the present deceased Milords, that is Ravindra. This Ashish was the one who has took earlier Bharti to their home. This Ashish Milords has done everything. Yet Milords, this Ashish has not been examined before the honorable. It is he's not named in the charge sheet. He's not made party to the present. Everything is silent around this Ashish.
Yes.
Now, Milords, what has happened on 1911-2020? This Bharti ran away from his home and was situated at some railway station, as per statements of this very prosecution witnesses.
Yes.
Now, it is alleged this wise
Yes.
that Bharti was called upon at some place, some common place.
Yes.
This all persons met there,
Yes.
and this Ashish, not this Ashish person who is third party in the present proceeding, has
Yes.
beaten up Ravindra.
Yes.
Milords Sachin, being prosecution witness 15, it is on exhibit 76, the common friend,
Yes.
the common liquid between both families.
Yes.
So Sachin took Bharti to their home on 1911-2020.
Yes.
Now, Milords, after all this, on 21/11/2020, the
Yes.
family of Bharti takes her to village. It is Uttar Pradesh,
Yes.
their home village.
Yes.
હવે સાહેબ આપ વિલેજમાં લઈ ગયા 21 તારીખ. There are no evidence as such. There is no documentary proof or there is no at all any independent witnesses citing કે yes, તેમના ઘરે તાળો હતો એ લઈ ગયા હતા 21 તારીખ.
Yes.
Nothing comes on record. It is merely statement.
Yes.
Now, Milords, after that, on 29/11/2020, સાહેબ આ ભારતીનો બીજો incident.
Yes.
It is alleged this wise, સાહેબ, કે
Yes.
Bharti has ran away from his home, his
Yes.
village to Ahmedabad. સાહેબ, અહેમદાબાદમાં એને રવિન્દ્રને call કરી.
Yes.
Ravindra came to pick her up.
Yes.
They went sightseeing. And in the morning, Ravindra took her to some hotel. That is Milord's Lakshmi Palace, Nipur.
1.
This comes from the Milord's deposition of PW 13.
13,
13, 1 3.
not 7.
Not 7, 13.
Yes. 13. Yes, PW 13.
PW 13, Ravindra, that is the lover of Milord, has deposed this wife.
Yes.
But he had picked up Bharti. He had taken her to some hotel, namely Lakshmi Palace.
Yes.
That is confirmed by prosecution witness 20. They were residing in that very hotel.
He took Bharti
He took Bharti,
to hotel Lakshmi Palace.
Lakshmi Palace at Nicole.
Yes. Yes.
Now, Milords, after this,
Yes.
from the statement of prosecution witness 7,
Yes.
Raj Durai, that is the sister of Ravindra.
Yes.
In his statement, it comes on record this.
Yes.
Ravindra has, સાહેબ રવિન્દ્ર પહેલા એને હોટલમાં લઈને ગયો. પછી રવિન્દ્ર came out of that hotel at around 9:30 in the morning. He went back at his home.
Yes.
From his home, this is Milord's corroboration from prosecution witness 17 and the Ravindra, this prosecution witness 13. He went home. He had conversation with his brother, that is prosecution witness 7, and also his sister, that is prosecution witness Milord's
Yes.
70.
Yes.
એના પછી સાહેબ એ બંને લોકો
Mm.
એને લઈને બંને એટલે ચારે લોકો સાહેબ, because Sachin was a common friend of him. સાહેબ
Yes.
સચિનને એમને ફોન કર્યો. This comes on record of the deposition itself. સચિનને સાહેબ ફોન કરે છે. આ ચારે લોકો સાહેબ they went to the hotel. હોટલમાં જઈને સાહેબ સચિન calls upon their family relatives, that is the deceased family.
Yes.
As Milord's deceased family was in the village,
Yes.
so only 2 persons were here.
The Sachin called.
Sachin called upon. એટલે અહીંયા સાહેબ બે લોકો, it is alleged કે સાહેબ બે લોકો અહીંયા હતા.
Yes.
એના નાના સાહેબ અને એના
Yes.
માસ.
Yes. Family of disease.
Family.
Yes.
Now it comes on record from prosecution witness 17 that she went upstairs to the hotel. એટલે સાહેબ ધરતીને કંઈક સમજાયું. ધરતીને સાહેબ નીચે લઈને આવ્યા, ભારતીને નીચે લઈને આવ્યા.
Con.
Prosecution witness 17, રાજપુર.
Yes. Sister
of Milord's prosecution witness
13.
30.
Yes.
સાહેબ નીચે લઈને આવ્યા. Now, while stopping here, Milords,
Yes.
in the same deposition of prosecution witness 7, Milords, it comes a very contradictory statement this wise.
Yes.
Mahindra goes on saying,
Yes.
we were called upon at some far end of a place from that very hotel, a Amul stand.
Yes.
So Ravindra went inside that hotel,
Yes.
took Bharti out, and on his motorcycle, they all reached towards Amul.
Yes.
That comes from deposition of prosecution witness 7. That is,
Yes.
Milords, very contradictory to the statements of 17 and 30.
1.
Now, Milords, from statement of prosecution witness 7, 13, 15,
Yes.
till Milords 17
No.
and 19, till 19, 15 till 19, are the persons who were actually present at the site when this was happening.
Yes.
Now, Milords, there is many contradictions in each other's story. That's why
Yes.
some persons, that is Milords Sachin, who is prosecution witness 50, and Milords from prosecution witness 16 to 19, who are friends of this Mahendra, states this wise that they saw Bharti coming downstairs and they have handed Bharti to her Nana and Masi, and they straight away went to their home.
Yes.
Now to the contradiction of this vice, where for establishing of a case,
Yeah.
for say, prosecution has not submitted this vice in the deposition of only prosecution witness 7 minutes.
Yeah.
That Bharti was beaten up in that very auto rickshaw, and she was abused by her aunt. So only from statement of prosecution witness 7, this comes on record. Rest, all other witnesses who are the eyewitness of that very incident,
Bharti was beaten by whom?
beaten by her milord's Masi while sitting inside the rickshaw, and was abused by her.
While in rickshaw. Other witnesses have not.
Other witnesses have contradicted that he was simply hand over to them, and they simply went there.
Yeah.
Now, my lords, after this, when that Bharti reached his home,
Yes.
from 29 till 30, everything was silent.
29.
Till 29th November till 30th November, everything was silent. On 30th November in the evening, Bharti calls Ravindra. It is confirmed, my lords, from the testimonies of all prosecution witnesses, and
Yeah.
my lords also the caller.
Yeah.
Bharti called upon in the evening to Ravindra. And this is also, my lords, forming part of the deposition. That સાહેબ મારા ઘરવાળા મારી ગયા છે, તું અહીંયા આવી જા. મારા ઘરવાળા લગ્ન માટે રાજી થઈ ગયા છે, તું અહીંયા આવી જા. To which, my lords, Ravindra was, for instance, ready to go there.
One. Yes. Yeah.
For that very instance, Ravindra was not acknowledging it and wanted to come from the deposition.
Yeah.
But from the deposition of PW 13, 7 and 17, it comes on record that PW 17, that is Raj Dudani, who is the
Yeah.
sister of Ravindra,
Yes.
has stopped him from doing it.
Yeah.
એટલે સાહેબ એમના ઘરે આવ્યો નહીં.
Yeah.
And thereafter, my lord,
The family members of Ravindra prevented him.
prevented him to go to place. Family members is particularly acute check PW 17, that is Raj Dudani, said no.
Yes.
Now, my lords, on the morning of
Yes.
the dark morning of my lords 1/12/2020,
Yes.
a burned body is found near the railway tracks, the meter gauge railway. એટલે મેઘાણીનગર ફાટક પાસે મીટર ગેજ રેલવેમાં સાહેબ ખબર
Crossing. Railway crossing.
રેલવે ક્રોસ.
Yes.
સાહેબ, while stopping here,
Yes.
I put 5 propositions
Yes.
before myself
Yes.
that if at all it is a story of the prosecution,
Yes.
that that is us, the whole accused have burnt her hair, and it is the body of this very victim only.
Yes.
Then I put a question before myself.
Yes.
First of all, is there any witness of transportation of her to that place? Because as per their story, it is us who have first strangulated her, then who have સાહેબ એને ફાંસી ઉપર લટકાઈ,
Yes.
એના પછી સાહેબ બોડી કોથળીમાં લઈને we have went to that very place and burned.
Yes.
Now સાહેબ these persons are residing in a chawl,
Yes.
a highly densely populated chawl.
Yes.
And from that very chawl to that railway crossing comes 4 to 5 different highly populated chawls. It is not something that you can come from a main highway.
Yes.
So, from that very chawl to that railway crossing,
Yes.
no eyewitness is stating the transportation of that very body was examined or may not at all made a part of prosecution itself. It was not even investigated.
One. No witness. Yes.
Second thing, my lord, is very સાહેબ આ ફાટક હતો એની સામે જ સાહેબ સ્કૂલ આવેલી છે.
Yes.
ભગવતી સ્કૂલ. School name is Bhagwati School.
Yes.
And many other commercial offices as well as plots are there, which are equipped by CCTV camera. That body અળગાવી હોય, irrespective of it being burned on a daylight or on night,
Yes.
that કંઈક તો આવે.
Yes.
But this very fact needs to be proven by prosecution.
Yes.
And they have miserably failed to even address this very thing.
Yes.
No CCTV has been put forward for this very subject. Third, my lords, the allegation of the prosecution is this wise,
One.
that for the transportation,
One.
the
And this building and school are equipped with CCTV footage.
equipped with CCTV camera.
Let us come on record in whose testimony.
Lords, it does not fall under any testimony because it was not even investigated.
This aspect has come on record. You are saying that your arguments is to the fact that near the railway crossing, there is school, there are offices and plots equipped with CCTV cameras.
On the Panchnama, it reflects that there is also a mandir here. The CCTV camera એવું કોઈ આવતું. Not from the record.
These are your contentions?
Not some contention, but CCTV camera છે એ નથી. That is not been investigated.
Yes.
Third, my lords, another contention of the prosecution is this wise, that some vehicle was being used to transport the body of victim. That recovery of that vehicle is not been done.
Yes.
Fourth point, my lords, the offense which is the prosecution footing fourth is, my lords, she was burnt. Now, from the medical evidences itself, the
Yes.
FSL report, twice FSL reports,
Yes.
and from the examination of the prosecution witness, that is the doctors,
Yes.
it cannot be ascertained what kind of fuel was being used.
Yes.
And no such fuel bottles are recovered from anywhere near.
Yes.
My lords, fifth, that is the very important point that the prosecution feels
Yes.
of reliance is, my lords, witness of burning.
Yes.
If my lords may kindly peruse the FIR.
Yes.
The FIR was given by Ravi Parikh, which is prosecution witness 25.
Yes.
In his FIR, my lords, the contentions are this ones.
Yes.
એ સાહેબ પોતાના માલિકીનું ઘર ધરાવે છે.
Yes.
સવારે woke up, he had a bath,
Yes.
he went under that bridge
Yes.
for urination.
Yes.
એને સાહેબ ત્યાં body burning જોઈ
Yes.
અને લોકોનું ટોળું જોઈ.
Yes.
That comes from the FIR itself, the face of FIR.
Yes.
And that is how this FIR came to be launched.
Yes.
Now, my lords, prosecution.
Yes.
Playing Mala fight team. In his statement that is on exhibit 120, he goes on saying, who in brief cheche man, any niche umuj.
Yes.
He goes on saying that. Total contradiction.
Yes.
Secondly, he goes on saying that Ratre,
Yes.
in the time of the Karo, but Ratre, in time, he saw some silhouettes or some shadows of few persons. That is 4 males and 2 females.
Yes.
Exactly. He saw 4 milots, males and 2 females, dragging something in Kothadi. And using some substance like petrol to burn it. So, my lords, when he was asked in his cross-examination,
Hmm.
that did you tell this in FIR or any prior statements before police authority or anywhere? He says, and he further states that this is first time coming.
Yes.
So, my lords, this witness is not at all, my lords, to be relied upon.
Yes.
The whole story is based upon pure assumption. He is not, my lords, expert. And more towards, my lords, he is not an eyewitness.
Yes.
My lords, his testimony is legally unreliable. Now, my lords, moving further, all the punch witness, almost all punch witness except one punch witness. That is, my lords, prosecution witness 4.
PW
14, sir. 14. 14, sir. Any allow other punch witness have turned step. Now, what 14th punch says, એ સાહેબ પોલીસ વાળા જોડે આમના ઘરે ગયો જ્યારે આમના ઘર ઉપર તાળો હતો. That is the accused person's room.
Yes.
And they have collected certain muddamals from that very place,
Yes.
which are not made part of the present proceeding.
Yes.
Because it is not true that which not weapon is used, or is there a rope for string for લટકાવવા માટે સાહેબ એને strangulation માટે કઈ use કર્યું હોય.
Yes.
For burning, if some substance is used, nothing is there.
Yes. And nothing recovered during the course of investigation.
From the every punch has turned hostile, and even otherwise from each and every panchnama, nothing comes on record linking the accused person to the any act of burning or strangulation, etc.
Yes.
Now, Lords, Section 27 confession of the Lord's Mama at initial. Now, prosecution witness 9 was the punch.
PW9 punch.
PW9 was the punch when his statement was been recorded. That PW9 has turned hostile.
One. Statement of
Under
A2.
Exhibit 42 and punch now is under
A2.
Exhibit 42.
A2
A2.
was recorded. This punch in his presence.
In his punch, that confession was recorded.
PW9.
PW9 is the prosecution witness.
Yes.
Punch. Thus, we not the Panchnama is not.
One. PW9. પંચનામું શરૂ કર્યું. આરોપી નાઓએ પોતાની સ્વકૃષિથી કહેલ ડેમો અમારી દીકરીને પગે ચાલતા પ્રશ્ન તેમાં મૂકીને તેના This is the confession of accused A2.
A2.
Whether anything was discovered at the by virtue of this Panchnama. Yeah.
On page number 6 of that very option.
No.
Para 6.
Reconstruction, this is reconstruction પંચનામા.
ના સાહેબ એને જ્યારે અરેસ્ટ કરવામાં આવ્યો ત્યારે સાહેબ એનો સ્ટેટમેન્ટ જે રેકોર્ડ કરવામાં આવ્યો કન્ફેશન સ્ટેટમેન્ટ ઓફ ધીસ
Reconstruction you. PW9.
PW9.
એ વાત ખરી છે નથી કે મેં મારા એવું તફાવત છે તે.
This is reconstruction one now.
This has led to recovery of bottle.
Recovery of water.
Yes.
On 6 on para 6 he says કે મને મુદ્દામાં બતાવવામાં આવે તો ઓળખી શકતો નહીં. મને મુદ્દામાં આર્ટિકલ નું નંબર 1 વાળી બોટલ બતાવવામાં આવે છે. મને જણાવું છું કે એવી કોઈ બોટલ કબજે કરવાનું છે.
Yes.
If he has turned hostile. Not coming upon the medical evidence.
Yes. Well, paper now.
Yes, where there is no eyewitness.
One. Yes.
Case where there is no eyewitness.
Yes.
In this case, not the circumstantial evidences or say the medical evidences would have to be linked together to prove a case of murder. Not prosecution has reached this rise. At first, there was a strangulation. wherein this accused number 1, who being a father,
Yes.
accused number 1, who being a father of the present deceased, is alleged to have been set upon the deceased, has strangulated and all other family members
Yes.
have હાથ ને પગ પકડી રાખ્યા. They were allegations.
Yes.
એના પછી after that strangulation she was hanged.
Yes.
સાહેબ વચ્ચેથી સ્ટોરીમાં I don't know why the prosecution has proceeded this. And
You are
thereafter
taking charge of 201 also?
201 also.
Yes.
Why 201 my lords this wise? After this
Yes. Now you carried
strangulation
the body
is a
to some
body
different place,
body.
and there now you burnt the body. The pura or not so.
હવે સાહેબ medical evidences જોવામાં આવે
Yes.
તો સાહેબ link which has to be proved along with that circumstantial evidences
Yes.
is my lords not. By way of postmortem, Dr. my lords, it is PW11 exhibit 14.
PW11 doctor. Yes.
He
He is
goes
the
on
doctor who has performed the postmortem.
postmortem, first initial post.
Yes.
He says, my lords, the body was completely burnt.
Yes.
All the tissues were charred.
Yes.
चबाई गया. And internal organs were also affected by those burns.
Yes.
So by way of that gadama side,
Yes.
strangulation થયું છે કે ન થયું, that cannot be ascertained. Secondly, my lords, it cannot be ascertained that was there a healthy mortem or post-mortem injury. He goes on saying that he is not so sure if there were injuries before the body was burned or after the body was burned. And lords, thirdly, there is not at all any single evidence put forth by the medical examination, which would at all singly suggest any act of strangulation of throat or thought.
Yes.
એક જ મિનિટ છે સોરી
Yes.
મેં મારા સજેશનમાં પૂછ્યું છે બસ
Yes.
ના પાડી છે સાહેબ,
સજેશનમાં છે
Yes.
એવું થઈ શકે નહીં સાહેબ, એવું લખ.
Yes.
If I વાંચી ને
Yes. So PW11 ની વાત છે.
PW11
મારે પેલા તાર તપાસમાં છેલ્લા પેરેગ્રાફમાં
PW11. Yes.
કોઈ વ્યક્તિને જલ્દ પડદાન કે પેટ્રોલથી સળગાવવામાં આવે તો પીએમમાં દર્શાવેલ દાઝી જવાની ઈજાઓ થઈ શકે અને આ દાઝી જવાની ઈજા કારણે શરીર પરની અન્ય ઈજાઓ દેખાય નહીં. જે લાશનું પીએમ કરેલ તે સંપૂર્ણ દાઝી ગયેલ હતી અને સંપૂર્ણ દાઝી ગયેલ હોવાથી ઈજાઓ મૃત્યુ પહેલા કે મૃત્યુ પછીની હતી તેના અભિપ્રાય આપી શકેલ નથી. સાહેબ એના પછી સાહેબ if my lords the kindly page with para 10 it also comes on.
Para?
On para 10 on the last statement એ વાત કરી છે કે પીએમ કરતી વખતે ગુજરનારને ગળું દબારી મારવા નાખવાની કોઈ હકીકત જણાવી આવેલ નથી.
Para 10.
Para 10.
પહેલાનું જે છે એના કારણે પેલું વોશ આઉટ થઈ
જો
જાય.
કોઈ વ્યક્તિને જલદ પદાર્થ જેવા કે પેટ્રોલ થી સળગાવવામાં આવે તો પીએમ ના દર્શવી જાય ઈજાઓ થઈ શકે અને દાઝી જવાની ઈજાના કારણે શરીર પરની અન્ય ઈજાઓ દેખાય નહીં.
એટલે સાહેબ એ સ્ટેટમેન્ટ એમના પોઝિટિવમાં કરે પછી નેક્સ્ટ ઓન 10 ઇન નેગેટિવ.
જે
સ્ટેટમેન્ટ ઇઝ
પીએમ કરે તે
same.
સંપૂર્ણપણે દાઝી ગયેલ હતી અને તે સંપૂર્ણપણે દાઝી ગયેલ હોવાથી તે ઈજાઓ મૃત્યુ પહેલા કે મૃત્યુ પછીની હતી તેનો અભિપ્રાય આપી શકેલ નથી.
notes facts remains that there is no evidences which would suggest that there was any strangulation or throat.
શરીર ખૂબ જ દાઝી જવાના કારણે છેડ થવાના કારણે ગળાનો ભાગ મિસિંગ હોવાના કારણે દાઝી જવાની ઈજા મૃત્યુ પહેલાની છે તે જાણી શકાય તેમ નથી. Yes.
Not on the similar stance.
Yes.
Prosecution witness 12. When the second postmortem came to be conducted, he states similar.
What has come on record during cross of PW11? વાત કરી છે કે તે સિવાય કોઈ ક્લેમ કરવામાં આવેલ હોય તે
On para 10 it says એ વાત કરી છે કે PM report વખતે ગુજરનાર ગળું દબાઈને મારી નાખવાનું કોઈ ચીજ જણાવેલ આવી. Thereafter notes on
એ વાત કરી ક્યાં છે? There are 10?
para 10
Yes. Where?
on the very last
Yes.
sentence.
PM કરતા પહેલા પોલીસ એમર્જન્સી એ વાત કરી છે કે PM કરતી વખતે ગુજરનારને ગળું દબાવી મારી નાખવાની કોઈ હકીકત જણાઈ આવેલ નહીં. Yes. Yes. Yes.
And so there are various statements coming after that. It cannot be assumed that it was petrol. On para 13 it comes on.
There are 13.
Para 13.
Yes.
પેટ્રોલની હાજરી ક્યાં સુધી જોવા મળે તે અંગે ડોક્ટરે જણાવ્યું છે કે હું કંઈ કહી શકું. પછી પણ સર પીએમ દરમિયાન જોવા મળે ત્યાં પીએમ રિપોર્ટ દરમિયાન થાઇરોઇડ બોન મિસિંગ હોવાના કારણે ગળા પર પ્રેશર આવવાની તે મિસિંગ હતું કે કેમ તે હું કહી શકું.
Yes.
And this is the similar stance has been taken by prosecution witness 12.
Yes. Yes. PW12.
PW12.
Yes. Yes. Yes, we'll continue after this. Yes.
If I quickly summarize,
Yes.
I was arguing with the aspect of medical.
Yes, doctor.
The
PW12.
of PW notes that it is an inconclusive thing.
Yes.
કે સાહેબ એ લોકો બતાવી નથી શકતા what is the cause of that. And if we go by the story of prosecution, સાહેબ એમાં એ બતાવી નથી શકતા whether was there any strangulation. Moreover, સાહેબ આની અલાવા that medical examination also cannot prove was it a self-burning, an accidental burn, or post-death burn. Therefore, my lords, in my respectful submission,
One. Yes.
therefore, my lords, in my respectful submission, the suicide becomes a reasonable hypothesis in the present matter. કારણ કે સાહેબ, it points towards the emotional distress of the very victim, the deceased, the failed love, relationship, my lords, in the refusal of marriage. Crunching all these facts in aspect, a case of suicide rather than, my lords, murder exists.
Yeah.
And when there is a hypothesis over suicide, my lords, a murder cannot be standing on the same pedestal.
Yes.
Lords, I will move towards the core argument, that is, if any charge of E0, that is
Yeah.
murder, would be existent.
Yes.
In
Yeah.
order to prove a charge of murder,
Yes.
the motive, knowledge, etc. needs to be proven.
First condition, motive,
Motive.
motive not proved.
Motive is not proved in the present case. Why not?
Yeah.
The very legal position of motive is this wise. Motive is based in the present case. It is based upon the circumstantial chain of evidence,
Yes.
wherein it is a case of prosecution.
Yeah.
કેસ લોક સાહેબ એવું કહેવા માંગે છે prosecution.
Yes.
સૌથી પહેલા સાહેબ કે જે victim ના ઘરવાળા હતા, they were of abusive nature,
Yeah.
which they not miserably failed to prove.
Yeah.
બીજું સાહેબ, they were trying to opt this wise. એ લોકો સાહેબ મેરેજ માટે ઘરવાળા રાજી નહોતા.
એક. Yes.
Step 3 2. બંને વસ્તુના કારણે first it is their abusive nature and secondly their denial over that marriage of both of them. They killed Bharat. Now let's, while countering this,
Yes.
we have ready evidence on our hand.
Yes.
First, my lords, I would like to take my lords to prosecution witness 13's deposition,
Yes.
wherein he eagerly mentions કે સાહેબ ભારતીની ફેમિલીએ ક્યારે એને થ્રેટન કર્યું.
Mm.
In his deposition, he states,
Mm.
secondly, Sahib, he also has
Ravindra.
Ravindra, the lover of the deceased person.
Yes.
Secondly, my lords, there was no confrontation. Ravindra Sahib પેલી છોકરી જોડે ક્યારે, the family જોડે ક્યારે મળ્યું. Nothing comes upon on record wherein this Ravindra has ever met the family of the deceased. But my lords, if the family was of so objected of the relationship, at least some case or something would be against him.
Yeah.
That koi case કર્યું નથી. There is nothing on the record to suggest that there was a oppose of the relationship. Rather, my lords, on 30th 11/2020,
Mm.
it was Bharti who called upon this Ravindra, stating કે મારા family વાળા રાજી થઈ ગયા છે લગનમાં. But it was Ravindra who did not, thereby proving, my lords, it was a decision in an emotional distress of Bharti
One.
and not a motive of the family to kill. Because જ્યારે family ready હોય,
Yes.
there would not at all be any motive of killing.
Yes.
Apart from, my lords, PW 13, that is Ravindra, the lover, PW 15, that is Sachin, who is the, my lords, common friend of this family, and 16, 18, 19, who are friends of Ravindra's brother, PW 7. They also are of such nature. The statements are of such nature, my lords, that nobody has at all from the family of Bharti has assaulted.
Yes.
When Ashish comes on record, but that Ashish is not made part of the present prosecution. Moreover, my lords, on 30th/11/2020,
Yes,
જ્યારે સાહેબ ભારતીને લઈ જવામાં આવ્યું એના ઘરે
yes,
હોટલમાંથી, ત્યારે પણ my lords, there was not at all anything which suggests abusive behavior on the record. Rather, it is a contradictory statements coming upon of the prosecution to itself. Thus, my lords, there was no family hostility towards
one. કેટલા બધા મેળા છે? અહીંયા થઈ ગયું છે? તો જાઓ ને બધા.
सेंट्रल जेल
બીજી કોર્ટની હાજરી આવી ગઈ.
બપોર પછી છે ને મેટ્રોપોલની હાજરી બધી હતી કરે
ઓકે સર.
એટલા કમિટ ના થયા હોય
યસ.
my lords, in order to prove what the prosecution is trying to prove, that is, my lords, a case of honor killing.
યસ.
The main element is in honor killing.
ઓનર કિલિંગ.
Honor killing.
ઓનર
આખો prosecution નો કેસ જ honor killing. કે મારે એને લગ્ન કરાવવું નતું એટલે the accused family has killed. That is the whole case of proceeding. Honor killing. Because if they are suppressing honor killing, then an essential ingredient has to be fulfilled in honor killing. That is the
Yes.
prior conduct.
યસ.
Lords, prior conduct, there was no kidnapping complaint ever lodged against this relative. No missing complaint, my lords. સાહેબ સમાજમાં બેસીને મીટિંગ એ નથી એમના બંને વચ્ચે. And there is no independent neighbor witness which would suggest otherwise. એ ઝઘડતા હતા તેમને રવિન્દ્રનાથ.
યસ.
Lastly, this moves the point of motive towards the point of suicide.
યસ.
This way, side. કારણ કે Bharti was lost emotionally dependent upon this
યસ.
of the lover. સાહેબ એના કારણે સાહેબ બે વાર ઘરેથી ભાગી ગઈ હતી અને ઇમોશનલ ડિસ્ટ્રેસમાં હતી એના ઉપર
જગદીશભાઈ
ઘરવાળાઓને માનવા પછી even after ઘરવાળા were રાજી, Ravindra avoided marriage, and due to that,
Bharti was emotionally attached with Ravindra. And so
એના કારણે સાહેબ she ran with her
Bharti
twice.
called. Whom she called? Called Ravindra.
No, she ran away with Ravindra twice.
Called Ravindra. That her family is ready for
Marriage.
marriage and he should come. Yet
Ravindra avoided. Does not point towards a motive of murder. Rather, it points towards an starting position of a distress and position towards Millard's an independent suicide, which initially was being investigated, Millards, but out of nowhere that was converted to treason.
well,
Millards, of the motive angle, there is not at all any motive proved by the prosecution. and the motive are allegedly not contradicted by the prosecution witnesses themselves.
Yes.
Thus, my lords, the whole pillar which they are basing of the motive here by my lords emerges.
Yes.
These I would point towards which they are very much claiming is last scene theory. Now, in order to put a last scene theory before any prosecution story, there needs to be a complete linkage of.
Yes.
Because in order to prove a last scene theory,
Yes.
there needs to be a basis that accused was the last person with whom the deceased was.
Yes.
Secondly, my lords, the time gap between last scene and that is very short. And my lords, third, there is no possibility of any third party intervention.
Yes.
As I've thrown a vastu proved high, and when there is a chain of link of chains,
Yes.
then only the last scene theory can be at all regarded before this online,
Yes.
which my lords is not seen from the present time.
Yes.
Can I say on 29/11/2020,
Yes.
સાહેબ આ લોકો આરતીને હોટલમાં લેવા જાય છે. હોટલમાંથી એને એના આંટી આંટ અને નાનાને સોંપી દેશે.
Yes.
Thereafter, when Bharti is at his home,
Yes.
there is not at all any neighbor witness
Yes.
or any family quarrel witness alongside, or not any CCTV recordings which would suggest otherwise to prove the last incident. And there is not at all any independent witness itself to prove it.
Yes.
There will be not only a sole independent witness. जैसा मैं कही सकता हूँ कि हमें लोग भारतीय ने घरे मुक्त, that is the auto rickshaw.
Yes.
That is been examined. He is prosecution witness 21. He has also done hostile.
Yes.
Therefore, my lords, accused was not last seen, and the chain is very much broken.
Yes.
My lords, there is always a possibility of third party involvement. The case of suicide, my lords, already in existence.
Yes.
But lastly, I would like to point out not their argument, because these two things, that is the motive
Yes.
and the chain of circumstances, has to be said in a Varva matter. There needs to be an efficient or enough amount of circumstantial evidence. It is
Yes.
corroborated with that story.
Yes.
There is no eyewitnesses.
Yes.
Confession is not true because Panchas has turned hostile. There is no recovery of any weapons.
A true confession, not true.
Yes, there is something. Like pardon me for sir, ये A2 no तो A6 no confession.
A6.
A6. He is Masa of the deceased.
Yeah.
What would be, my lords, that there is no recovery of weapons?
Their ban condition is not with regard to usage of any weapon.
Except a kerosene bottle that they are relying upon,
Yeah.
or any weapon for strangulation. So in the story, say, later on she was hanged.
Their case is to the fact that previously she was strangulated, and subsequent thereto, she was fired with usage of some fuel
Yes,
at different place.
yes.
Yeah.
So their story is in 5 years. That's how the Pella, they are trying to prove that Bharti had love affair with Ravindra. Himna Manis.
Yeah.
Then after it comes on record, they say family members were angry about the relation.
Yeah. Yeah.
Or it comes around the family members due to such angriness.
Yeah.
Saudi Pella साहब इन्हें strangulate करवा.
Yeah.
Then fourth साहब strangulate करीने. Body in body में साहब evidence ना रहेगी for destruction of evidence. They later on burned.
Yeah.
And एना पछी they disposed of that body near the railway.
Yeah.
That is what comes from the charge sheet. So if we examine each and every chain under this, Saudi Pella Sahib being a love affair of Bharti with Ravindra, it is an established fact.
Yeah.
Secondly, there say that family members were angry due to the relationship. Totally false. Because it is the Bharti who called upon Ravindra,
Yeah.
stating that Bharwala mani gaya है, and it has been proven.
Yeah.
Third and fourth, Lord, this strangulation, અને સાહેબ જે body બાળવામાં આવી,
Yeah.
there is no medical evidence is supporting that.
Yeah.
Apart from this, there is no any individual independent witness is suggesting ત્યાંથી મારીનમાં આવ્યો ઘરે કઈ બબાલ ચાલતી હતી ત્યાંથી બોડી લઈને પછી ચોલમાંથી સાહેબ
Yeah.
a densely populated area, એ populated area માંથી સાહેબ રેલવે ફાટક પાસે લઈને there is no evidences
Yeah.
and there is no CCTV evidences of such record apart from the mere testimony of the complainant.
Yeah.
That too afterthought.
Yeah.
Under the whole of this, the chain of circumstantial evidences are not.
Yeah.
I am permitted to tender some judgment.
Yeah.
Honorable Supreme Court. So I may start reading from Parati.
Yeah.
The present one is a case of circumstantial evidences. The prosecution led evidence on established on three linked of states. Motive, last seen and recovery of weapon of assault. The pointing out of here. The High Court, while dealing with the evidence on record, agreed with the findings of motive and last seen. Now, so far as the recovery of weapon of assault and bloodstained clothes were concerned, the High Court in paragraphs went from the judgment. And the same to the invalids, also to the extent to say the recovery which has been made does not indicate the appellant committed the crime. Still, it observed that looking at the entire gamut and over other clinching evidences against the appellant of last seen and motive upon the conviction. Now, notes from third it says, Honorable Supreme Court says we do not find such conclusion of the High Court to be strictly in accordance with the law. In case of circumstantial evidences, the chain has to be complete in all aspects, so as to indicate the guilt of the accused and also exclude any other theory of crime. The law is well settled on the above grounds. Reference to the head to mills in the following.
Yeah.
Further, Milord's very recent judgment I mean 1910.
Yeah.
Or if may not see kindly turn to second page only. I will only read from the head note on. Investigation, grave lapse and apathy. Investigation was conducted with pedantic and rigidity and rank apathy. The investigation officers failed to promptly identify and record statement of crucial witnesses, establishing the ownership position of the house from where recoveries were made, maintain a proper chain of custody for seized articles, conduct DNA profiling despite it being reliable scientific tool available, and explain how the accused was apprehended. These lapses undermine the fairness and diligence expected in a serious case, creating a legitimate apprehension that the investigation may have been intended shield to the real offense. Recoveries and forensic evidence. The alleged recovery of the bloodstain articles from the accused house was initiated. Punch witnesses contradicted each other and the IO on the deed of manner of recovery. The IO admitted to not collecting any proof of ownership of those stones. The parents of the victim were never asked to identify the recovered clothes. The chain of custody from Caesar to FSL was also not. Consequently, the FSL report confirming so and so was also no evidence. And because later on section 27, the prosecution failed to prove the memorandum statement of the accused under section 27, leading to the recovery. The arrest memo was also not proved. The accused deny all circumstances put to him under section 3. And one of the later judgment, I may kindly tender before my phone. I may kindly start read from para 50. Because it highly focuses upon the motive aspect, the circumstantial evidence chain linking. From para 51. Having considered the evidence in the entirety and bearing in the mind the principle of governing cases resting purely upon circumstantial evidence. We are of the opinion that the prosecution has failed to establish the complete and unbroken chain of these circumstances necessary to bring home the guilt of accused appellants. Firstly, as regards to motive, the prosecution has merely alleged that the accused appellants were travel well, so and so. However, no independent or credible evidences has been adduced to substantiate such a motive. A barred assertion without corroboration cannot by itself form a self basis of conviction. Secondly, the last seen theory relied upon by the prosecution supports from serious infirmities. The prosecution has failed to prove the proximity of time and place so as the shift of the burden onto the accused. Thirdly, the scientific evidence itself riddled with the deficiencies. The alleged theory so and so notes, then the prosecution claims, then after notes the facts of the present case, the case itself comes and thereby notes likewise the omission of examining crucial witnesses including the so and so who first informed the police about the location of the dead body and so further weakens the case of the prosecution. No individual independent witness notes were examined in the present case. 53. It must be borne in mind that the present case involves the imposition of ultimate punishment of death. The law is well settled that in cases resting on circumstantial evidence, every link in the chain must be firmly and conclusively established, leaving no room for doubt. Where two views are possible, the one favorable to the accused must be adopted. In the instant case, the prosecution has failed to prove motive. The last seen theory stands contradicted, and the alleged scientific evidence is marred by inconsistencies and serious loopholes. In such circumstances, it would be wholly unsafe to uphold a conviction, much less the extreme death. Lords, Earl has lost his life in this very tragedy.
Yeah.
But my lords, tragedy cannot justify conviction without feeling. My lords, justice is not about punishing someone, but it is not about punishing the guilty. Ama Sahib, I being the prime accused in the present, Sahib, हमारे को छोकरी चाहिए थी. And I am being left with nothing. Now the investigation is trying to grab me and put me somewhere where I do not belong. and they are trying to hide the original Milord's criminals,
Yes.
were by way of which Milord's this case has to be prosecuted.
Yes.
By this Milord's I rest my case.
Yes.
Miley open.
Yes.
Patient here.
Yes. You are representing A1 to A5?
From A1 to A5. For A6 here.
એ વીકલીમાં સહી છે કે નહીં?
मैं पेलू
Proxy. Yes.
દાદા રિશ્વા ખાલી એક જ લીધી હતી.
हमने पूરું कर लिया પછી કેશું
ઓકે.
हमने पूરું कर लिया
I am for accused number 6, Your Honor.
चल पहला yes your initials
SR यादव. हमने ये तो આપી છે પણ નામદાર કોર્ટે 400 પ્રશ્નો ક્વેરીમાં પૂછેલા છે.
yes yes
તમે કહ્યું તો નહીં.
yes
Your Honor,
yes
after the argument of my learned friend,
yes
this honorable court had suggested me to give answers to certain questions.
yes
The first one was victim and Ravindra had relationship.
yes
Second one, it was disliked by family members.
yes
They were last seen 3 times
yes
and meeting by the family members.
yes
On the day before victim was burned, that is on 29/11, the victim was beaten by it.
yes
All these questions, Your
Yes.
Honor,
yes
do not relate to me. I am accused number 6.
yes
This is a case of circumstantial evidence.
you are related to the deceased
I am maternal uncle. The prosecution is stating
yes
that I had abetted the offense of
yes you the offenses of abatement
abatement. It would be the case, if at all,
yes
and screening the offense here under section 201
yes
and 302 of IPC. I will not go on the question of charge of 306, 302, etc.
yes
I will limit myself to the
yes
questions put forward. Otherwise, my written arguments I
yes
have already submitted.
yes
ઓરલ એવિડન્સ અને જે ક્રોસ એક્ઝામિનેશન એ જોવામાં આવે.
yes
તો સાહેબ હું બનાવવાળી જગ્યાએ
yes
અન્ય આરોપીઓ સાથે રહેતો હતો એવો કોઈ પુરાવો નથી. સાહેબ આ પહેલા 3 પ્રશ્નના
1 minute yes
હવે સાહેબ લાસ્ટ થિંગ 3 ટાઈમ્સ છે
yes
એમાં on the last day it is stated that I was sick.
yes
અને એ દિવસે સાહેબ
yes
જે હોટલમાં ભારતી મળેલા વિક્ટીમ
yes
એમનું સીસીટીવી ફૂટેજ આઈઓ એમની ઉલટમાં કબૂલ કરેલું છે કે સીસીટીવી ફૂટેજ જે છે
yes
એની સાથે 65 દીની સર્ટિફિકેટ છે.
yes
એટલે the last thing theory loses its significance.
मतलब નથી દેખાતા
એમાં તો હું તો ક્યાંય નથી. હવે સાહેબ ઓરલ વિટનેસીસ એવું કે છે કે we had beaten.
yes
તો ફરિયાદીનો ભાઈ અને ફરિયાદીના મિત્રને
yes
પૂછવામાં આવ્યું કે એજ્યુકેશનલ ક્વોલિફિકેશન બંનેની સરખી હતી, મરનારની અને રવિન્દ્રની,
Yes.
જે with whom the victim had love affair.
Yes.
બંનેની આર્થિક સ્થિતિ બી સરખી હતી
Yes.
અને બંનેની ઇકોનોમિક સ્થિતિ બી સરખી હતી અને બંનેનું કસ્ટમ્સ અને ટ્રેડિશન બી સરખી જ છે. દે બિલોંગ ટુ આઉટ ઓફ સ્ટેટ ઓફ ગુજરાત. એટલે કાસ્ટ ડિફરન્સ બી નથી, લેંગ્વેજ ડિફરન્સ બી નથી, રિલિજન નો ડિફરન્સ બી નથી, એજ્યુકેશનલ ડિફરન્સ બી નથી. અને the person with whom the victim had love was called by the parents. એ નથી જઈ શકી.
Yes.
હવે સાહેબ હું આરોપી નંબર 6 તરીકે જોવામાં આવે તો એફઆઈઆર બી સાહેબ સર્કમસ્ટન્સીસમાં ડેડ બોડી મળેલું
Yes.
એટલે એમાં કોઈ રોલ મારું નથી.
Yes.
મારું કે પ્રોસિક્યુશન નું કેસ એવું છે કે મને દૂર મારા ગામડેથી પકડીને લાયા છે,
Yes.
મોટરસાયકલમાં ડેડ બોડીને લઈ ગયા છે.
Yes.
મોટરસાયકલ મારી હોય
Yes.
એનું કોઈ આરસી બુક કે એનું કોઈ પરમિટ કોઈ બી વસ્તુ મને કનેક્ટ કરતી મારી મોટરસાયકલમાં હું લઈ ગયો.
Yes.
તો પ્રોસિક્યુશન નું કેસ એવું છે, એક બે ના સ્ટેટમેન્ટમાંથી એવું આવે છે કે પેટ્રોલનું જે બોટલ છે હું લઈ આવ્યો. That was not through discovery જે છે એ અન્ય આરોપી તરફથી છે. There is no recovery or discovery at my inspection.
Yes.
અને એફએસએલ અધિકારીને સાહેબ પેટ્રોલિયમની હાજરી બાબતે પૂછવામાં આવેલી. He could not definitely say. The person, I am not a person who would be against the marriage of my niece, Your Honor. અને બનાવ પહેલા હું ત્યાં રહેતો હોય, બનાવ પછી હું બનાવ વખતે હાજર રહ્યો હોય,
Yes.
કોઈ પણ પ્રકારે વિરોધ મેં કર્યું હોય
Yes.
એવું કોઈ કેસ નથી. Merely on the basis of statement of co-accused, I cannot be roped in such a heinous case. જે પેટ્રોલિયમ બોટલની રિકવરી કહેવાય છે એ અન્ય આરોપી પાસેથી છે સર, મારી પાસેથી. I will limit my argument to accused number 6 only. I am grateful.
Yes.
ये सब रिकवरी डिस्कवरी ऊपर मैं जजमेंट एक पे मुकिया है. I will not repeat.
Yes. ચલો અમને ખબર છે. તમારે કોઈ જજમેન્ટ ને કંઈક રજૂ કરવાનું હોય તો
એક જ જજમેન્ટ છે 2006 12 SCC 254. જે લાસ્ટિંગ ટુગેધર છે એના માટે સાહેબ આરોપ સેક્શન 106 છે એવિડન્સ છે એ આ કેસમાં લાગુ પડશે સાહેબ, કારણ કે છેલ્લા ટાઈમે બંને આરોપીઓ અને મૃતક એમની સાથે હતા. પછી શું બનાવ બનેલો એનો કોઈ ખુલાસો એ લોકોએ FS માં કર્યો નથી. એ adverse influence આરોપીઓની અગેન્સ્ટમાં.
સાહેબ એક જ સેન્ટેન્સ છે સાહેબ 106 facts within the special knowledge નું મિસકન્સેપ્શન છે મારા માનીએ. અને દરેક ક્રિમિનલ કેસ સાહેબ it depends upon the facts and circumstances of each case.
Notes. On us, rather my lords, nothing shift over. It is only the prosecution to prove a case beyond reasonable doubt.
जजमेंट क्या है
હું આપી દઉં સર 2012
संबंधी?